Judges at the International Criminal Court have terminated charges and declared a mistrial in the case against Kenyan Deputy President William Ruto and journalist Joshua Arap Sang. The judges, however, say the case is subject to re-prosecution in future. Ruto and his co-accused radio journalist were accused of 3 charges of crimes against humanity, namely murder, forcible deportation and persecution. This follows violence that erupted after Kenya's disputed elections in late December 2007. They both denied the charges. The case has been widely watched by many across Kenya and the African continent.
The Chamber considered the requests of Mr. Ruto and Mr. Sang, that the Chamber find that there is no case to answer, dismiss the charges against both accused, and enter a judgment of acquittal. And the Chamber also considered the opposing submissions of the prosecutor and the legal representative of the victims, and received further submissions during hearings that were held from 12 to 15 of January 2016. On the basis of the evidence and arguments submitted to the Chamber, Presiding Judge Chile Eboe Osuji and Judge Robert Fremer, as the majority, agreed that the charges are to be vacated and the accused are to be discharged.
Let's get more details and analysis on this case from CCTV's Jack Parrock, who's standing by in Brussels. Jack, what more can you tell us about this decision from the ICC?
Well, it's an incredibly significant decision, both for the International Criminal Court and for Kenya. From the point of the ICC, it shows that this case has fallen down, and there's been some accusations, even within the judgment from the judges, of meddling of the Kenyan government, preventing evidence to be used. Essentially what's happened here is that the prosecutor especially alleges that the Kenyan government has tampered with witnesses and got them to recant their evidence. And back in February, the judges in the trial chamber decided that evidence that has been recanted in this trial can no longer be used. Then the defence applied for a no case to answer motion, and judges today have decided that that can be upheld and that these 2 men can see the charges against them vacated. It doesn't mean that they can't be prosecuted for these crimes against humanity's charges in the future. That is still an option, and the prosecution, if they find future evidence, could try and go up against Deputy President William Ruto and the journalist Joshua Sang and try and restart the trial. Whether that happens, we'll have to wait and see in the coming days. We've not heard too much from the International Criminal Court, apart from that statement from the ICC spokesperson that we just heard then.
And have we had any reaction from the prosecution? Do we expect them to contest the verdict?
No, indeed. So the prosecution hasn't said yet, but there is an option that they could appeal this, but that might be difficult. What the Office of the Prosecutor might do, what Fatou Bensouda, the ICC prosecutor, might do, is try to go out and collect much more evidence in order to restart some sort of trial in the future. At the moment, the case has fallen down, but the judges, 2 of them said that this no case to answer motion should be upheld and that the 2 men should see the charges vacated, but 1 was not happy with that and dissented, which means they disagreed and felt that the trial should continue. So there isn't a unanimous decision, and the Office of the Prosecutor might feel that if they can get some more evidence, they can get this trial restarted. Having said that, it's obviously a significant loss for the Office of the Prosecutor, who saw the case against Uhuru Kenyatta, the Kenyan president, that was linked to this post-election violence charges, the same as William Ruto and Joshua Sang were facing, dropped back in November 2014. And they are essentially furious about this. The Office of the Prosecutor was very, very upset when the Kenyatta trial was thrown out, and so she'll be very upset about this trial being thrown out as well. But what it might do is ease some tensions between Kenya and the International Criminal Court. The Kenyan government has fought hard against the ICC and even raised the idea of a mass withdrawal of AU countries, African Union countries, from the jurisdiction of the ICC. And now with these 2 really high-profile Kenyan trials being dropped, the Kenyan government might ease off on their pressure against the International Criminal Court.
Right, Jack Parrock in Brussels. Thank you, Jack.